Good afternoon or good evening or good morning, depending on when and where you're watching this, but it's the afternoon of June 10th, 2024. I'm doing an extra live today. Why are we doing an extra live today? Because after a full day of trial coverage, I really wanted to cover this ruling. It happened last week. We did not have a chance to cover it last week. I'm going to give a quick road so far, and then we're going to get right into this ruling. It is the only topic today because the court has made a massive ruling in the TikTok psychic defamation case, and we all need a minute of a break from the wildness happening in the Karen Read trial. So I'm going to roll the intro and we're going to get right into it. I am ready to read this ruling. I am ready. I am here for it. For those of you that are in the chat that have not been following this case because you found me during this trial coverage, let me know if you're new to this. Just pop a 1 in the chat. We're going to roll the intro. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Law nerds that are new to this case. All right. So in Idaho, I have been following the Bryan Kohberger case since the indictment. In the time between the quadruple homicide in Idaho and the charging of Bryan Kohberger, there was lots of speculation on social media, as there can be with any high-profile case that grabs the nation's attention. Most of the time, I find that speculation unhelpful. On rare occasions, information gleaned from those who have learned about the case online can actually help the investigation. What I have generally found to be true is that those that help the investigation go directly to investigators, not so much to the internet. The TikTok psychic, who is the defendant in this defamation case, took to TikTok to say that it was her belief that a professor at the University of Idaho, in fact, committed or commissioned these murders because she had an illicit affair with one of the students and was trying to cover up the affair and or was jealous. And so she hired someone, and then they brought in Kohberger to commit these murders. And she called the professor a murderer, which can be defamation per se, amongst other horrific things that this professor at the University of Idaho History Department was a part of. In all of the motions leading up to this, I have listened in on all of the motion arguments because though this is federal court and they are not streamed, they were made available to call in and listen to. So I have listened to these arguments and broken them down for you. What stage of the proceedings we are at is the summary judgment. Summary judgment is when we've gotten beyond the motions to dismiss in the early litigation. At summary judgment, the court can make rulings that are dispositive, final, and dispose of the case. The motion for summary judgment brought by Rebecca Schofield was, hey, there's no evidence of truth. The defendant can't prove that this is based on anything. And the defendant said it's based on my psychic inquiry. It's based on my clairvoyance. It's based on my tarot cards. It is based on the things I have gleaned from my guides. So I believe that what the professor did was, hire someone to murder for University of Idaho students. And then doubled down on that in the argument with the court. And as the court was questioning her, and if you haven't seen my coverage of the last court hearing, which was the argument for this on April 17th, the court said, do you have any other evidence? And she said, I asked my tarot cards. I gleaned from my guides with my clairvoyance that this is what happened. She also talked about the fact that she is God and that she can't be found liable for defamation because these things are her opinion. The TikTok psychic, some of you will say, but Emily, this person clearly is not operating in reality. And while that might be true, she is not operating in the reality that some of us are operating in. She was incredibly savvy in her arguments with the court. A lot of it was word games, the way that you will see some of the witnesses in this case play, but they were parsed, linear, logical, and strategic choices. But the court was looking for objective evidence that the assertions and statements made were true. And I don't think the court got that. So, in the court's questioning of the TikTok psychic, I said that I thought the court would grant the motion for summary judgment. And that's what the court has done. The court has granted the plaintiff's motion for summary judgment and granted plaintiff's motion for leave to amend the complaint to add punitive damages. Remember, those are the punishment ones. What does that mean? Well, it means that as to liability, the TikTok psychic has been found liable by the court for defamation. And that when this goes to trial, the only question for the jury will be how much. There were times when we were getting through this that I was like, I disagree with the court. I disagree with the court. And I'm like, but I said, the court is making the long play. The court gave this defendant every opportunity, more than she would have gotten had she not been representing herself. This court, I think, went above and beyond giving this defendant chance after chance after chance. And what the court ruled is that she is liable for defamation. The jury will determine damages because this is defamation per se. And punitive damages are on the table. Whether this defendant is judgment proof or whether the defendant will ever be able to pay them is separate. But the court has brought in the find out to the fuck around that we have been looking at since this was filed. That doesn't mean that this plaintiff has not had to go round and round on this case. It doesn't mean that the weight of having to go through litigation like this. How do you clear your name with somebody who says, I'm God, and, you know, because I have aligned my flesh, this was in the phone argument, because I have aligned my flesh with the spirit, I have clairvoyance, and you are a murderer. At one point in the argument, the court was arguing with the TikTok psychic and saying, questioning, and saying, but you have presented no evidence that this is true. How? And the response from the defendant was, how can you trust the word of a murderer? E.g., the plaintiff in this case. So the court is not going to be dealing with, but Your Honor, this is my truth. The court is not going to give a lot of weight to, but Your Honor, I'm a spiritual witness. The court, it seems, has not given a lot of credibility to, Your Honor, it is my right to practice my religion, which is not what the court is saying at all. The court is saying what you need is objective evidence. And at some point, should the TikTok psychic have seen this coming? Do you want to read the court's order? Do you want to read the court's order? I would like nothing more. I would like nothing more than to read the court's order. So I want nothing more than to go over this with you, because at the end of the day, as I am trying to figure out how to do a stream that is not a trial stream, at the end of the day, sometimes there needs to be, I don't know, some level of justice. And defamation cases can be incredibly difficult. But from the beginning of this case, we have gone through this being like, this is defamation per se. And this defendant has fought like, I don't know, everything to try to say, Nuh-uh, Your Honor. Well, the clout circus is closed now. Remember, that was in the early filings that the defendant turned this into a clout circus. The clout circus is closed, ma'am. The court has found that you have defamed the plaintiff, and when you go to trial, you are going to have to show up in Idaho, and you are going to sit there during a jury trial on the damage that you have caused in this individual's life. So, shall we? Memorandum decision and order regarding the plaintiff's amended motion for partial summary judgment and plaintiff's motion for leave to amend complaint and add punitive damage. This is from June 6, 2024. Factual and procedural background. We're going to hear the court's summary of my summary. This case arises out of the tragic murder of 4 University of Idaho students in November 2022. Plaintiff Rebecca Schofield is a professor at the University of Idaho. She alleges that despite never meeting any of these students or being involved with their murders in any way, defendant, TikToker, posted over 100 sensational TikToks and later YouTube videos, falsely claiming that plaintiff, 1, had an extramarital same-sex romantic affair with one of the victims, and then 2, ordered the 4 murders to prevent the affair from coming to light. Plaintiff sent cease and desist letters to the defendant in the following days and weeks. And then what do content creators do when they receive cease and desist chat? They turn them into content. And that's exactly what happened. When the defendant did not stop, plaintiff initiated this action. Plaintiff asserts 2 defamation claims against defendant. One is premised on the false statements regarding plaintiff's involvement with the murders themselves. The other is premised on the false statements regarding the plaintiff's romantic relationship with one of the murdered students. Remember, this is a university professor being accused of having an affair with a student, which goes against the ethics and all of the codes of conduct that the professor adheres to. So it is accusing the professor of a crime and then accusing the professor of impropriety in her profession. So that is why the 2 causes of action. Defendant, representing herself, did not immediately respond to plaintiff's complaint by the January 17th, 2023 deadline. Yes. And then we all went, dismiss it. And then it didn't happen. As a result, pursuant to Rule 55A, plaintiff moved for an entry of default against the defendant on January 19th. A clerk's entry of default was then entered and mailed on January 27th. On February 16th, defendant moved to set aside the entry of default, and the court granted it. Plaintiff responded the next day, opposing the efforts to set aside the default and filing a motion for default judgment pursuant to Rule 55B2. On April 24th, the parties consented to the judge's jurisdiction. Thereafter, on April 26, 2023, the court granted defendant's motion to set aside the entry of default, denied plaintiff's motion for default judgment as moot, and ordered defendant to respond to plaintiff's complaint within 21 days. The court said, I'm going to give you another try. On May 16th, defendant filed her answer, affirmative defenses, counterclaims. Remember, the TikTok psychic tried to sue the lawyers for defaming her by filing a lawsuit. Within that pleading, defendant denied that she defamed plaintiff because the accusations made against plaintiff in defendant's TikTok videos are, quote, substantially true. Quote, Rebecca Schofield planned, ordered, and executed the murder of 4 University of Idaho students. Since the accusations in TikTokers' videos are substantially true, there is no actionable claim for defamation. Remember, truth is a defense. Defendant further maintained that she, quote, used her spiritual brain, this is a direct quote from her filings, used her spiritual brain, intuition, spiritual practice, and investigative skills to uncover the truth regarding the murder of the 4 University of Idaho students and publish her findings on her TikTok social media platform. Defendant also affirmatively asserted 11 counterclaims against plaintiff and her legal counsel, relying on 2 premises. 1, that plaintiff initiated, planned, and executed the murders to cover up an affair that she had with one of the murder victims. And 2, that plaintiff sought to evade suspicion for these murders by conspiring with her counsel to file a quote-unquote frivolous complaint with a falsified factual allegations. I can't read today. that A, supported the defamation claims against defendant, and B, deprived defendant of her constitutional rights. On June 6th, plaintiff moved to dismiss defendant's counterclaims against her. A week later, plaintiff moved to quash the summons for her counsel, arguing that their issuance was procedurally improper. It was. Defendant opposed these motions. In an August 8th memorandum of decision, the court granted the plaintiff's motion to dismiss, insofar as it dismissed the defendant's counterclaims against plaintiff and granted the motion to quash. You can't sue the lawyers for suing you, saying that the lawsuit's defamatory. On August 21st, also at one point, the defendant did try to claim like influencer privilege. It was way back in the early days of this suit. It was like, it's privileged. I'm allowed to say what I believe on TikTok. She also tried to claim First Amendment, freedom of religion, and the rest. On August 21st, 2023, defendant requested the court's August 8th decision and order be set aside under Rules 60B4 and 6 because, one, this court does not have subject matter jurisdiction over her action. Ma'am, you cannot just watch Legally Blonde and start throwing subject matter jurisdiction around. 2, this court does not have personal jurisdiction over her. 3, the venue is improper in Idaho. 4, the court lacks judicial impartiality. And 5, the court does not have subject matter jurisdiction over the plausibility of spiritual practices. Look, this case probably had a solid argument about venue and some jurisdictional arguments, but those were waived very early on. You know what she should have done? Asked her lawyer about it. Ask your lawyer. But she didn't. So, the plausibility of spiritual practices was interesting. All right. The court denied defendant's motion in its entirety on November 13th, 2023. The court was like, nah. Nah. In the interim, plaintiff moved for partial summary judgment as to liability on each of her 2 defamation claims against defendant. Plaintiff's argument in this respect were largely based on defendant's, the court's getting spicy, on defendant's complete failure to respond to plaintiff's earlier served requests for admissions. Quoting the Federal Rules of Civil Procedure, a matter is admitted unless within 30 days after being served, the party to whom the request is directed serves on the requesting party a written answer or objection addressed to the matter and signed by the party or its attorney. So she didn't respond to any of the requests for admission or the request for admission, the interrogatories, or the discovery. Sorry, after streaming 7 hours, my brain is a little, apologies. However, on December 7th, the court granted defendant more time to respond to plaintiff's request. When I say that this court was like, look, you didn't respond, but I'm gonna go ahead and give you more time to respond. You need to respond. You need to respond. You need to respond. The court gave her more time to respond and extended plaintiff's motion deadline to address defendant's anticipated responses. Defendant eventually responded to plaintiff's request for admissions. On January 12th, plaintiff filed the at-issue amended motion for partial summary judgment, again moving the court for partial summary judgment as to liability on each of her defamation claims against defendant. Footnote 2. In light of plaintiff's amended motion for partial summary judgment, the court denied as moot the plaintiff's original motion for partial summary judgment. Plaintiff contends that the defendant's admissions, the TikTok videos that defendant posted online, and the plaintiff's own declaration established beyond dispute that defendant defamed her. At one point, this defendant doubled down and started name-calling the judge on YouTube. That's never going to go well. Ever. Also on January 12th, plaintiff filed the at-issue motion for leave to amend the complaint to add punitive damages. Plaintiff contends that defendants' repeated and ongoing defamatory statements about her without any factual support whatsoever are extreme, outrageous, and warrant a claim for punitive damages. Defendant opposes each of those motions, claiming again that her statements about plaintiff are either true or have been proven to be false or have not been proven to be false by the plaintiff. That's not how any of this works. It's like, excuse me, she's not proved that it's not true. So if it's not true, then it's true. No. On April 16th, the court heard oral arguments, if you can call it that, on plaintiff's pending motions. Yeah. The oral arguments were interesting. So, for the reasons discussed below, the motions are granted, which means the TikToker has been found liable. Motion for summary judgment. Summary judgment is appropriate where a party demonstrates that as to any claim or defense, quote, there is no genuine dispute as to any material fact and that the movement is entitled to judgment as a matter of law. A fact is material if it might affect the outcome of the case. Hold on, I've got to text my mom right now. Hey, I'm streaming. I'll call you back. So, sorry, Mom. I'll call you back in just a moment. A fact is material if it might affect the outcome of the case. A factual dispute is genuine if the evidence is such that a reasonable jury could return a verdict for the non-moving party. One of the principal purposes of summary judgment is to isolate and dispose of factually unsupported claims or defenses. It is not a disfavored procedural shortcut, but it is instead the principal tool by which factually insufficient claims or defenses can be isolated and prevented from going to trial with the attendant unwarranted consumption of public and private resources. So a lot of you have asked, how does this even get this far? Well, it just has to go through the proper channels to get to the point where the judge can yeet it. This is the time when the judge can yeet it. The moving party bears the initial burden of demonstrating the absence of a genuine dispute as to material fact, and then the burden shifts. To carry this burden, the moving party, here the plaintiff, must identify portions of the record together with affidavits that it believes show the absence of a genuine issue of material fact. If the moving party satisfies the initial burden, so step one, the burden then shifts to the non-moving party to demonstrate with specific facts. Facts, not mere conclusory allegations, the existence of a genuine issue of material fact. What genuine issue is there? What genuine issue of fact is there? The existence of a scintilla of evidence. It's like a LaCroix. We've talked about it as a LaCroix of evidence where it's just a whiff. A whiff, a scintilla is just like me. So the littlest bit, the existence of a scintilla of evidence in support of the non-moving party's position is insufficient. It needs the littlest whiff is enough on a motion to dismiss. Here, there needs to be a little bit more. The non-moving party must do more than simply show that there is some metaphysical doubt as to material facts. But all you need is a little bit, not the teeniest bit, but a little bit of evidence. It's a chinchilla of evidence. Thank you, Trisha. The court likewise need not accept allegations by the non-moving party if such allegations are not supported by sufficient evidence. There needs to be evidence. Claim for punitive damages. Punitive damages claim is words are hard. A punitive damages claim is substantive in nature and accordingly controlled by Idaho law in diversity cases. In Idaho, no claim for damages shall be filed containing a prayer for relief seeking punitive damages, but a party may, pursuant to pretrial motion and after hearing before the court, amend the pleadings to include a claim. So in Idaho, the court is saying you cannot just file punitive damages. You can't just do that. But you can make a motion and ask. The court shall allow the motion to amend the pleadings if, after weighing the evidence presented, the court concludes that the moving party has established at such hearing a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. Can you show that punishment damages are needed? To support an award of punitive damages, the claimant must prove by clear and convincing evidence, which is a pretty low bar. Clear and convincing is one of the lower legal standards in civil law. Oppressive, fraudulent, malicious, or outrageous conduct by the party against whom the claim for punitive damage is asserted. So is the TikToker's conduct oppressive, fraudulent, malicious, or outrageous? It doesn't have to be all of them. It just has to be one of them or any combination thereof. Let's see what the court decides, because we don't need to go through the standards together. Let's see the judge's analysis, shall we? The plaintiff's amended motion for partial summary judgment, docket number 63. Plaintiff asserts 2 defamation claims against defendant. The first claim concerns defendant's statement that plaintiff orchestrated the murders of 4 University of Idaho students. The second claim concerns defendant's statements that plaintiff had been involved in an inappropriate same-sex relationship with one of the murdered students. Plaintiff argues she's entitled to summary judgment on the issue of liability, finding defamation or not defamation. Remember, in civil law, liability or no liability, it's not, what am I thinking? My brain is so tired. I'm sorry, you guys. After streaming for 7.5 hours, I'm like, my brain is so tired. The issue of liability. Wait, what am I thinking? My train of thought just absolutely jumped. Oh, liability. Remember, because we're in civil and we are dealing with liability, yes or no, not guilt or innocence. So you're either liable or you're not liable for the thing. Did you do the thing? Are you responsible for the thing or not? My brain absolutely watched the entire train derail there for just a moment. So the issue of liability, because the evidence establishes that both sets of standards are defamatory as a matter of law. In Idaho, a plaintiff claiming defamation must prove that the defendant, 1, communicated the information concerning the plaintiff to others. Was it communicated? Well, the TikToker admitted that those were her TikToks and she said what she said. So, communicated. 2, the information was defamatory. That's where we get into defamation per se. 3, that the plaintiff was damaged because of the communication. Defamation per se also plays in there. The parties mostly agree that this is the standard applicable. There was some argument about the standard, and I actually thought that the TikToker did a good job in court of expressing the argument over the standards, because the TikToker is like, no, this standard versus that standard. And they argued the difference between the standard for public figure and non-public figure linearly. And I thought, well, for sure. So this is the court summarizing that. Plaintiff contends that for each of the defamation cases or defamation claims against defendant, the record establishes the first 2 liability-specific elements. The court agrees. First, in both print and internet publishing, information is generally considered published when it's made available to the public. The TikToker said they're TikTokers. They're TikToks and they're hers. Here, it's undisputed that the defendant communicated information concerning plaintiff to others via defendant's repeated social media postings. Quote, defendant admitted that she stated publicly that plaintiff murdered 4 students and that plaintiff had an affair with one of those students. And there is a note from the declaration of the plaintiff's attorney noting how certain of defendant's social media posting received thousands of quote unquote likes. Defendant alleged that when she was 100% sure of that message that she received from her cards and other things, that the plaintiff was in a relationship with the victim that broke up and that she initiated the murders, planned the murders, and hired help to carry out the plan, she revealed her findings on TikTok. That comes from a court hearing. The TikToker, when the court asked what research did you do, she said, I went to the university website and looked at the history department. I did readings on different members of the history department. I reconsulted my cards. And when I was 100% sure of what happened, that's when I published it to TikTok. That was what she said to the court in hearing. estimating that she posted over 100 TikTok videos of her findings. Defendant stating, quote, she posted her findings on social media. These social media posts continued even after defendant received plaintiff's cease and desist letters, after defendant knew that the Moscow Police Department issued a press release confirming that plaintiff was not involved in the murders, and after another individual, Bryan Kohberger, was arrested and charged. Second, a defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, ridicule, or by adversely affecting the person's business. And now we're getting into where the defamation per se, or the statements, get broken down in their entirety. Here, the information communicated about the plaintiff within defendant's social media postings are unquestionably defamatory. Well, we know how the judge feels about it. It accuses plaintiff of having an inappropriate same-sex romantic affair with a student and then masterminding that student's murder along with 3 other students to cover up the relationship, for example. The court's word, unquestionably defamatory. On November 25th, 2022, defendant posted a TikTok video highlighting a University of Idaho policy that, quote, Rebecca Schofield was so worried about being caught violating if anyone found out about her potential relationship with the victim. However, considering that they were broken up, there was really nothing to worry about. That's why she was worried about just losing the respect. On November 26, 2022, the TikTok posted by defendant stated that plaintiff and another individual partnered to kill the 4 University of Idaho college students. On November 28th, defendant posted a TikTok stating that, quote, I don't care what y'all say. The other individual and the professor killed the victims of the University of Idaho killings. The professor was the one to initiate the plan and hired the individual. November 28th, 2022, defendant posted a TikTok video rhetorically asking what the victim did, quote, that plaintiff felt was so bad she had to order her murder and the murder of the 3 other University of Idaho college students before taking a look into Rebecca Schofield and the victim's connection and stating that they partied together and that the plaintiff paid for the victim's automobile and travel expenses and that the plaintiff makes this quick, impulsive decision to have them killed, which ultimately ended up being all 4 University of Idaho students. On December 1st, on December 1st, defendant posted a TikTok video stating that Schofield isn't remorseful for ordering the murder of the 4 University of Idaho students, but is instead worried about her name, her accomplishments, worried about her possessions, worried about the people finding out who she really is, her real character, worried about her loss of accomplishments, worried about going to jail, losing everything that she has worked so hard for, worried about corruption and treason, not worried about the lives that were taken. On December 20th, the court really just listed all of it. The court's really like, hello, appellate court. If this is appealed, here. On December 2nd, defendant posted a TikTok video stating that the professor is going to prison for the murder of 4 University of Idaho students, whether you like it or not. On December 5th, 2022, defendant posted a TikTok stating that professor was being a sugar mama to one of the victims, giving her money. Victim saw this as an opportunity to get ahead. She had limited resources, and this was an opportunity. And also, it was like an experience. Professor liked the victim. She made her feel young and vibrant. And also, it was an opportunity for her to balance her needs for a woman. But she may have been pushing too hard because victim needed a break and some time to herself. She just needed to clear her mind. Professor just needed to take this time to slow down and appreciate what she has. During this time, victim looked like she was shining, successful, and other people are noticing. She may have even been shopping. During the break, professor was nervous, had anxiety, was worried about being caught, thought that the victim was going to backstab her, and that's when she decided to plan her murder and the other victim's murders, and she started looking for a team. On December 5th, the defendant posted a TikTok video stating that the plaintiff and the victim's relationship would have been something like a sugar mama, that the victim made her feel her professor like a kid again, very youthful energy. She did something for her. She helped her balance her needs, because otherwise that specific need that she had for a woman wasn't being taken care of. The victim had limited resources. She wanted to help her friends, but she felt like I have to help myself before I can help anyone else. So she made a decision that she felt was right for her. So the professor was giving her money and offering her money. I mean, if that was true, it would all just be in bank records. And the victim was really close to one of the other victims. So she opened up to her and told her about the money and that she was getting it from the professor, but the relationship didn't have a chance to start. The money came first. The victim looked at it like an experiment, but it became too much. On December 13th, 2022, defendant posted a TikTok video including plaintiff's cease and desist letter stating that Rebecca Schofield's attorney, Wendy J. Olson, sent me a demand letter to remove TikToks with false statement. I made no false statements. Kiss my ass. And I don't have to listen to this demand letter because it's claiming that I'm making false statements, and I'm not making false statements. What I'm saying is true. If they think I'm making false statements, they would need to file actual legal documents in federal court or in a court in my county asking me to remove it. A judge would then determine if I need to remove it. That way, an investigation could be had determining the truth and falsity of the statements. That's what we're here for. That's what we're here for. And the court has just determined that the statements are false. They're false. The statements are false. That's what's happening today. So you asked on December 13th for them to file a federal case, and they did. And then you go through a federal case, and you have. And then there's an investigation, and there was. And then a determination of the truth or falsity of the statements is made, and it has been. On February 8th, defendant posted a YouTube video. I think in the intermediary, defendant was removed from TikTok, is my understanding. On February 3rd, defendant posted a YouTube video detailing from the beginning her narrative of plaintiff's intimate relationship with the victim and eventual involvement in the murders of the 4 University of Idaho students, including how plaintiff has pictures, videos, messages during the night of the murder. On June 8th, 2023, the YouTube video of defendant interview with an online program, Nerd Report, was posted. The defendant described how she used her psychic gifts to solve mysteries and, to that end, how plaintiff orchestrated the murder of the 4 University of Idaho students, including how plaintiff connected with Kohberger on the day of the murders on a whim. Okay. On October 14th, defendant posted a YouTube, 2023, October 14th, 2023, defendant posted a YouTube video criticizing plaintiff's counsel as well as the court. Oh, it's in there. I didn't know if the court had seen it. It's in there. Oh, it's in there. Oh, it's in there. Melly, good to see you chat to chat today. It's in, look, it's, you guys, I didn't even know that would be in there. Oh, it's there. The only reason I saw it is because I think Marquis covered it. Marquis or Atuzzi, one of them covered it. Defendant posted a YouTube video criticizing plaintiff's counsel as well as the court for wanting to conceal the truth about plaintiff and the 4 students' murders. There and in the context of this action, plaintiff stated that she is dealing with criminals, dealing with a murderer who ordered the execution of 4 students, so quadruple homicide murderer, and that I am in court because I told the truth, and that person, Schofield, is threatened by me and the things I say. So anyway, I tell the truth. Yes, I can say what I said because I was telling the truth. Okay. By repeatedly accusing plaintiff of an affair with a student and then ordering the murder of 4 students to cover up the affair, defendant communicated information to others that was defamatory. Indeed, these statements are defamatory per se, meaning they are actionable without specific proof of damages. Statements are defamatory per se if they impute to the plaintiff a criminal offense, a loathsome disease. Sometimes that is described differently depending on the jurisdiction. If you'll remember from the Cardi B case in Georgia, I think it was a communicable illness, not a loathsome disease, but you can get an idea for the time period during which these things were written. Can't you? A matter incompatible with her trade. business, profession, or office, or serious sexual misconduct. It goes on to say if an alleged defamatory statement does not fall within one of these categories, then the plaintiff must allege and prove some special harm that resulted from the utterance. Defendant's statements about how plaintiff murdered 4 students and had a secret relationship with one of the victims in violation of school policy clearly meets this criteria. Crime plus profession. They impute not only conduct. Oh, I'm only keep reading. The judge has it handled. I like this judge. They impute not only conduct constituting a criminal offense that would be punishable by imprisonment, murder, but they also ascribe conduct that is incompatible with the proper conduct of a university professor, an inappropriate relationship with a student. Critically, in response, defendant does not dispute that she communicated statements about plaintiff to others, or that these statements, if false, are defamatory. That's true. The court said, but you can see how if they're not true, they're defamatory. And she said, but they're true. So it's wild. Absolutely wild. Rather, defendant argues, as she always has, that her statements about plaintiff's involvement with the victim in the murders are true. Defendant has consistently persisted. Can we consistently persisted? TikToker has consistently persisted that the statements she made regarding Schofield's role in the murder of the 4 University of Idaho students are substantially true. She did. And she's like, this is my defense. It's true. Gouliard admits, Gouliard admittedly states that the statements she made about plaintiff are substantially true. In other words, it is legally true that the professor hired an unexperienced hitman to commit the murder of the 4 University of Idaho students, and it is legally true that the professor had an affair with the victim. Defendant therefore asserts that it is plaintiff's burden to prove that her statements about plaintiff on her social media postings are false, and that plaintiff has not satisfied this burden on summary judgment. That was her argument. She was not correct, but that was her argument. TikToker has not proven that the statements, this is quoting from the motions, that professor has not proven the statements Gouliard made about her are false, that the professor has the burden of proof and has not submitted convincing evidence, that the statement that the TikToker made about her are false. Plaintiff must prove that the alleged defamatory statements are false. She said it over and over and over again. It's like, that's not how it works, but she was convinced that that's how it worked. She's like, no, I believe it's true. This was her argument, and I've listened to both of the motions hearings. I believe this is true. And if I believe this is true, you have to prove that it's false. Instead of her having to prove why it's true. So, plaintiff disagrees that it is her burden to prove falsity, countering that it is defendant's burden to prove that her statements are true. In turn, plaintiff argues that because truth is a defense to her 2 defamation claims, and because defendant cannot satisfy her burden to prove that defense at trial, then summary judgment is appropriate. Regardless, plaintiff submits that she has proven that defendant's statements about her are false, pointing to the complete absence of any evidence linking the plaintiff to either the murders or a relationship with one of the murdered students. Like, can you imagine having to go to court and your attorneys having to be like, but Your Honor, if she didn't do her assignment, I can't do mine. Like, how do you prove that you didn't murder someone other than being like, someone else was arrested. There's no evidence tying me to it. I wasn't in the state. You just can't say whatever. You just can't run around accusing people of crimes. But it took over a year to get here. Idaho case law does not clearly resolve which party has the burden of proving falsity or truth. And this is why I say the TikToker was very savvy in these arguments about the burden, because the case law is still not entirely clear on the defense of truth. Idaho case law does not clearly resolve which party has the burden of proving falsity or truth. Is truth a defense that must be pled and proved by defendant, or is falsity an element of plaintiff's prima facie case, their case in chief, that must be pled and proved by plaintiff? There is support for both positions in the case law. It wasn't just a frivolous argument. It was a very nuanced legal argument. For instance, as plaintiff notes in her briefing, the Idaho Supreme Court in Baker, I have nothing to do with it, endorsed a defendant's burden in this regard, stating, "It is axiomatic that the truth is a complete defense to a civil action for libel. In a slander or libel suit, it is necessary for the defendant to prove the literal truth of his statement in every detail. Rather, it is not necessary for the defendant to prove the literal truth of his statement in every detail. Rather, it is sufficient for a complete defense if the substance or gist of the slanderous or libelous statement is true." Truth, a true impression. Subsequent cases generally align with this same default reasoning. Ordinarily, the truth of a defamatory statement is a defense that must be proved by the defendant. Yet, an exception to the purported truth as a defense rule emerges where the alleged defamation involves a public official, public figure, or matter of public concern. And when I say it's nuanced, it's because we've gotten from like defamation is these three elements, then defamation per se, then defamation of a public figure. And that's where we've gone through the multiple levels of this argument. And it's not just above board. Or it's not just clear, I should say. This is above board. It's not just clear. In such cases, courts have required plaintiffs to plead and prove falsity. It says, however, even when the person alleging defamation is a private figure, where a newspaper article containing the alleged defamation discusses a matter of public concern, the common law's rule on falsity that the defendant must bear the burden of proving truth must fall to a constitutional requirement that the plaintiff bear the burden of showing falsity as well as fault before recovering damages. And that is from Philadelphia newspapers. After listing the above referenced three elements to a defamation claim, a fourth element, when a publication concerns a public official, public figure, or matters of public concern, and there is a media defendant, the plaintiff must also show the falsity of the statements at issue in order to prevail. So that was the TikToker's argument. Hey, the matter of the murder of the 4 university students is a matter of public concern, but I don't think that makes the plaintiff a public figure, and you can't drag somebody into something and be like, I've made them a public figure. They can do it themselves, but you can't drag them in. Further muddying the waters, Idaho jury instruction 4.82 requires plaintiff to prove falsity even where plaintiff is not a public official. This is not clear, right? In order to prove a claim of defamation, the plaintiff has the burden of proving each of the following elements. The defendant communicated the information concerning the plaintiff. The information impugned the honesty, integrity, virtue, or reputation of the plaintiff, or exposed the plaintiff to public hatred, contempt, or ridicule. And the information was false. And the defendant knew it was false, or reasonably should have known it was false. That's the public figure standard. That's the malice standard. And the plaintiff suffered an actual injury because of the defamation. That doesn't account when we are talking about per se. The amount of damages suffered by the plaintiff, we're not addressing that here. So it's not legally clear, and I appreciate the judge going through it. Where is footnote 3 coming from? Footnote 3 is from up here. Plaintiff implicitly argues that defendant has the burden to prove her statements are true since plaintiff is not a public figure. Defendant's statements do not concern a matter of public concern and or there is no media defendant involved in this action. And then the court notes public figure plaintiff's burden to prove the information was false and suggesting the plaintiff's burden to prove falsity cases involving media defendants. It goes on to say, courts in this district have at times adopted this alternate framework, noting the Idaho jury instructions, for the purposes of alleging and proving defamation claims. And then it lists all the case law that does that. And there's a footnote 4. Practically speaking, too, Idaho Jury Instruction 4.80 defines defamation as, quote, the communication of false information, such that if it is a plaintiff's burden to prove that information communicated to the public was defamatory under Clark, this would logically presume a concurrent burden to show falsity. So the jury instructions say a false statement. So who has to prove it's false? Which makes defamation, which seems clear on its face, much, much more complicated. It goes on to say the parties stake their competing positions, but do not grapple with this tension. Likewise, legal commentary largely comes up short in resolving the issue in any helpful way. The court is talking about legal commentary from the scholarly writings in Idaho and the case law. Like, we can't resolve the tension between what the standard is. But again, the defendant is a TikToker who is representing themselves pro se and raised a very complex legal issue in all of this, right? Hey, Court TV, good to see you. So the court says, even so, there is evolving support for the view that it is a public figure plaintiff's burden to prove falsity in a defamation action, even in cases like this one dealing with a non-media defendant and a matter that does not involve an issue of public concern. That is how it is in other jurisdictions. We saw this in Depp Heard. When you have public figures, you have what's generally called the malice element under the New York Times test. And the malice element is not only proving it's false, but proving that they knew that it was false, right? It says the wisest choice in these cases left open by Philadelphia is to place the burden of proof on the plaintiff, creating one uniform rule for all defamation cases. It says more significantly, the innocent until proven guilty aphorism should actually operate to put the burden on the plaintiff, not the defendant, if we intend to operate defamation rules to be at all consistent with the rest of the law of torts. For the traditional tort in every area but defamation is that because the plaintiff is invoking the heavy machinery of state power against a fellow citizen, the plaintiff bears the burden. It is the defendant who is deemed innocent of tortious activity until proven guilty. The only reason defamation has survived in some jurisdictions as an exception to this rule is the psychological transposition of the rules that defamation suits invite. The plaintiff is thought of as the person really on trial, for it is the plaintiff's reputation at stake. But once again, the law of torts routinely puts the burden of proof on plaintiffs when interests every bit as precious as reputation are being litigated. The common law exception for defamation simply cannot stand up to logical scrutiny. So, Court TV, oh no, we love Ant here. This is a TikTok creator. So no, it is not. We love Ant. This case has been going on surrounding the University of Idaho case for over a year now. And the court is here with a ruling on a motion for summary judgment, finding liability. So this view highlights the disconnect between the parties' arguments. It aligns with the defendant's position and Idaho Jury Instruction 4.82 while cutting against plaintiff's position and Clark. Ultimately, however, the court punted. The court need not resolve the issue given the record before it. I hate it when courts do this. I hate it when courts do this. I understand why the court's doing it, because I tell you guys, the court's not going to resolve shit they don't have to resolve, but come on. The court's like, here is a massive issue in the law. Here's where it sets up. Here is a massive issue in the law. Here is a disconnect in Idaho's jury instructions and Idaho's defamation rules. And the court lays it out like the most, unbelievable law school problem, and then goes, but we don't have to answer that question today. Come on. Your Honor, no! Just set up pages and pages and pages of this tension in Idaho's defamation law and then leaves it unanswered. Ugh. Ultimately, however, the court need not resolve the issue given the record before it. Right. The court's like, nah, it's defamatory. We don't have to answer who's got to prove what because there's no evidence. But there are issues in Idaho that are going to have to be resolved. That is, even if plaintiff's burden is to prove falsity, she has demonstrated that there is no genuine issue of material fact and that defendant's statements about her are false. So even if it's the plaintiff's burden, it's been met. Under the summary, I'm sorry to all the Idaho law students who are going to have to tackle these questions, because if I was a law professor in Idaho, I'd be like, this is a fantastic question. This would be a great law review article. Like, this is a fascinating, like, deep dive legal issue on the history of defamation law in Idaho that unfortunately we don't have time for today. And neither does the court. But fascinating. Just punting it up to all the law professors. Can someone please figure this out? Someone? It's a problem. Under the summary judgment standard, this would shift the burden to defendant to show otherwise. Thus, under either burden of proof scenario, defendant must demonstrate the existence of factual disputes pertaining to plaintiff's defamation claims. Defendant has no such evidence. To begin, plaintiff states in no uncertain terms that defendant's statements are false. She was never in a romantic relationship with the victim. She was not involved in the murders. She never met any of the murder victims. She never taught any of the murder victims. She did not personally know any of the murder victims. She was in Portland at the time of the murders. Hi, Fred. My cat is just staring at me like, why am I still streaming? Moreover, it says in response to plaintiff's subpoena, the university confirmed that it has no records of any of the students, the victims, being enrolled in a class taught by plaintiff. Any investigation into plaintiff having an inappropriate relationship or any investigation into plaintiff's involvement with the murders. The University of Idaho responding to defendant's subpoena stating that there were no records of any existing or deleted communications between plaintiff and any of the students or Mr. Kohberger. Finally, there is no indication that plaintiff is or ever has been even remotely considered a suspect. And then they talk about the press release from the Moscow Police Department. Quote, at this time in the investigation, detectives do not believe the female associate professor and chair of the history department at the University of Idaho suing a TikTok user for defamation is involved in this crime. To be sure, Kohberger was arrested and has been charged with the murders. This is powerful evidence at the summary judgment stage. It not only substantiates plaintiff's argument that defendant's statements about her are false, it also highlights the complete lack of any corroborating support for defendant's statements. In this way, plaintiff has sufficiently demonstrated the absence of any genuine issue of material fact relating to the falsity of defendant's statements about her. Like, what is a jury going to decide? Right? This shifts the burden to the defendant to dispute the claim by setting forth facts showing that there is a genuine issue for trial relating to whether her statements about plaintiff are true. In that regard, defendant, quote, may not rely on denials in the pleadings, but must produce specific evidence through affidavits or admissible discovery to show that the dispute exists. Except the only support for defendant's statements about plaintiff is that the defendant's, quote, spiritual investigation into the murders using, quote, intuitive tarot readings led her to plaintiff. And this comes from the defendant quoted out of the plaintiff's motion, quote, TikToker used her claircognizance. I don't know the difference. I'm sorry. I don't know the difference between claircognizance and clairvoyance, but claircognizant abilities to gather all the pieces of the puzzle of what happened to the 4 students and why. She became very passionate and touched by their stories and told by the intuitive tarot readings and their social media footprint. An intuitive tarot reading revealed that the professor would get away with murder if it wasn't for TikToker. At the time, TikToker did not know how that would happen, but she decided to continue to seek the truth regarding the murder of the 4 students and to advocate on their behalf. And then it goes into the motions confirming that with discovery closed, defendant has no other evidence of plaintiff's involvement in the murders or relationship besides her tarot readings. She did say she was a spiritual witness to this case. This is not enough, the court said, to create a genuine dispute of material fact. Fred, what do you need? To be admissible, and the court explained this at length on the call and kept asking if there was anything else. To be admissible, defendant's lay witness testimony concerning plaintiff's alleged conduct surrounding the 4 students' murders must be rationally based on defendant's perception and helpful to the fact finder, like a firsthand observation. An opinion is rationally based on a witness's perception where it is based upon personal observation and recollection of concrete facts. I bet this judge, and not just this judge, but this judge and this research attorney never thought they would be here having to explain what witness perception is of first-person witness testimony. Because the judge went around and around and around and around talking about this with this defendant and saying, but how can you testify to this? What did you see? Rule 701A contains a personal knowledge requirement. We have held that the personal knowledge requirement under Rule 602 is the same as that under Rule 701A. In presenting lay opinions, meaning, non-expert testimony, the personal knowledge requirement may be met if the witness can demonstrate firsthand knowledge or observation. Did you see the thing? Did you hear the thing? How do you know the thing? Go on, Fred. Go tell that Blue Jay what it's for. Go ahead. He's out there. Fred's staring at the birds. But crucially, there is no legal support for the proposition that tarot card readings are grounded in any objectively verifiable fact from which the defendant's testimony can ever be said to be rationally based. The defendant, based on everything I've seen in the filings and everything I've heard in the motion arguments, the defendant is not going to like that at all. At all. Like, not at all. But this is the grounding of the court saying you can't testify to that. There is no legal support for the proposition that tarot card readings are grounded in any objectively verifiable facts from which the defendant's testimony can ever be said to be rationally based. As a result, defendant's psychic intuition without more cannot establish a genuine dispute of material fact to oppose plaintiff's motion for summary judgment. And then there is case law citing about speculation. Speculative lay witness testimony is insufficient to establish a genuine dispute of material fact. Summary judgment may be appropriate if the non-moving party rests merely upon conclusory allegations, improbable inferences, and unsupported speculation. Footnote 6. Assuming Idaho jury instruction 4.82's application, an additional element to plaintiff's defamation claim exists that the parties do not focus on, whether defendant knew or reasonably should have known whether her statements were false. The defendant continued to post videos about plaintiff even after Kohberger's arrest, coupled with the complete absence of any evidence validating defendant's statements about plaintiff, indicates that at the very least, defendant reasonably should have known that those statements were false. Again, this goes to whether the malice element of a public figure, but the Idaho law is not clear on that, which is why the court included a footnote saying, even if this is required, all of this leads me to believe that she knew, right? At bottom, the totality of the evidence reveals that there is no genuine dispute as to any material fact that the defendant defamed plaintiff. Therefore, on the issue of liability only, plaintiff's amended motion for partial summary judgment is granted. That means the court has found by law that the TikTok psychic defamed the university professor. And then we get to punitive damages. This is going to be much shorter. Filed on the same day, plaintiff made a motion for punitive damages and argues that they're appropriate because defendant's defamatory social media postings represent the bad acts anchoring a punitive damages claim. Defendant acted with a bad state of mind given that the social media postings were made without any factual support and continued even after receiving the cease and desist. The Moscow Police Department press release on the issue and the arrest in the case. Plaintiff has established a reasonable likelihood of proving by clear and convincing evidence that defendant's conduct is in accusing plaintiff of an affair with a student before ordering the student and 3 other students' murders was oppressive, fraudulent, malicious, and or outrageous. As discussed above, the statements are defamatory as a matter of law and therefore represent a foundational set of bad facts. Further, those statements were based only on defendant's spiritual intuition about the murders. There was never any objective basis to believe that the plaintiff did the things that defendant publicly and repeatedly claims she did. While defendant eventually took her theory about plaintiff's involvement in the murders to law enforcement, she did so only after ignoring the cease and desist letters and going public with her claims on social media. Defendant admitting that she went to TikTok first. And defendant admitting she received the cease and desist letters and continued posting. Critically, defendant's social media postings continued even after she learned from Moscow PD that plaintiff was not a suspect and that Kohberger had been arrested. Defendant admitted that she received and read the press release and continued posting. The court asked her about it specifically. The indictment against Kohberger, which does not name plaintiff or provide any suggestion that any other person was involved, was also attached. These circumstances combined to demonstrate that defendant's social media postings were primarily self-serving, motivated by online viral attention. Your Honor, you stopped short of calling it a clout circus. Could you imagine a federal judge calling it a clout circus? The attorneys did. But can you imagine? Fred, I don't need your help on my keyboard, though. Thank you so much. Thank you so much, my big cat. But the keyboard help is not needed. Can you imagine if the judge had just said clout circus? It was in the first filings, but no. That's not what happened. So the court said that defendant's social media postings, that the circumstances combined demonstrate that defendant's social media postings were primarily self-serving, motivated by online viral attention, and made with an extremely harmful state of mind given the nature of the statements about plaintiff. Plaintiff's motion for leave to add punitive damages is granted. Whether defendant acted with such a harmful state of mind to support an award of punitive damages is a question for the jury and not the subject of this decision. So, what did the court do? Found the TikTok psychic liable for defamation and told the plaintiff that they can add punitive damages, which we learned together that in Idaho you cannot do without a hearing from the court, which actually I kind of like. That you can't just throw punitive damages in there all willy-nilly. The court gets to hear why you want punitive damages, and then the court gets to decide, like, none shall pass. So you can't use a massive punitive damages request to kind of hammer people into submission. I don't hate that rule at all. So what have we got? The quickest summary I can give you. This case is not all the way over, but it's mostly over because the court found the TikTok psychic liable for defamation and is allowing them to move forward on a trial for damages only, including punitive damages, which means the professor can ask for quite a lot of money beyond actual damages. It can be, hey, my reputation was damaged and I had to spend this money on this lawsuit and the money on the cease and desist and some of the other things that they might be able to ask. But we can't allow this behavior. Where are the limits? You receive a cease and desist, you put up a TikTok, basically, wiping your ass with it, not literally, hyperbolically wiping your ass with it, saying, I'm not going to do this. And juries might be persuaded by that. So this could still settle. I don't know if the pro se defendant will do that, but it could still settle. Would it be unwise to do that? No. I mean, I could see, and this is me just speculating, I could see the professor saying, look, here's a permanent injunction, the way that Cardi B did. Here's a permanent injunction, because I don't think they're going to get damages, but here's a permanent injunction. And you can't say any of this shit about me. You have to take this off of the internet and like never speak of it again. And we will not go after you for millions of dollars and chase you into eternity ad infinitum for that money. So would you like to be done? I can see that happening. So yeah, I could see that happening. Do I think the TikToker will do that? I don't know. Do I think that would probably be a good result for everybody involved at this stage of the case? Yeah, a permanent injunction would probably be a good result at this stage of the game. Lisa Lawless said injunctions violate the First Amendment. This defendant has been found guilty, well, liable, of defamation, and a permanent injunction can be part of a settlement on damages. They absolutely can. And we saw that again in the Cardi B defamation case out of Georgia. We saw a permanent injunction issued. Sometimes it is the proper remedy. So, but I don't know if we will see that, but I think they can absolutely be, I think they absolutely can be obtained. I don't know if the TikTok psychic, in consulting with her attorney herself, will decide what to do with that or decide to settle it, but it seemed like it should happen. But could this very really go to trial on damages alone? Yep. Yep, it could. Could you imagine? Could you imagine being the jury on that and being like, why are we here again? Why are we here again? You know. And when Lyndon pointed out in the chat too, the limitations on free speech. When we were talking about defamation, the reason you can bring defamation cases is because there are limits on what speech is, and we're dealing with private citizens at all. But I can't go much deeper into that because I was trying to wrap up and be done so that I can go eat dinner and get ready for tomorrow. But there are consequences here, and I think these types of permanent injunctions as a settlement to this case might be necessary and warranted. So that might be. Marianne Campbell said, I didn't play the questions. I'm sorry. Hold on. I'll be right back. So Marianne said in the chat that Natalie Lawyer Chick is covering the Young Thug stuff. And every time because there is the YSL Young Thug case and like the YNW Melly case, once I start with a Y, my brain always transposes the two. I saw briefly that one of the attorneys, I think Young Thug's attorney, was arrested today in court for contempt. I have not seen more information than that. I will absolutely go and take a look at Natalie Lawyer Chick's coverage of it, because I know there are multiple cases popping off. But after the shit that's popping off in Karen Reed, I can't even wrap my head around it. So go check out Natalie Lawyer Chick. I'm going to start wrapping this up. I'm going to answer a very few questions. So Natalie Lawyer Chick will have a breakdown. I'm sure there are others that are breaking it down. Natalie's a great defense attorney. If you guys don't know her, she practices in Maryland. She's funny as hell. And she's, well, I will go rely on her coverage because it's something that I am not paying close attention, because that trial has been going on for so long. And there's been so much that has happened in that case. So I'm glad Natalie's covering it. Really, really glad that she's covering it, because her coverage will not only be informative, but also hilarious, I am sure, because she's going to just like, so I'm going to answer a few questions and then we're going to go because, because there's other things. So thank you, Court TV. It's good to see you. Oh my goodness, this case. Well, we're almost done. Bernie Cat said, thank you for hanging with us all day. You are welcome. I love your nails. Thank you. I got my nails done over the weekend. It was time. I like going neon colors in the summer. It just feels right to me as we get into Pride Month, like the neon colors. It's just like, we need to be sparkly. And then I really wanted to try this glitter. So that's how we ended up with like glitter neon realness. So that's where we're at. I'm going to redo them one more time before VidCon. Will be something along these lines, though. I'm enjoying the like wild V French tip, and then I'm going to have to cut them. So for now they're staying like this. But let's see. Jasmine, good to see you. Said, did you see Young Thug trial? Judge held the defense lawyer in contempt. I saw that briefly because he wouldn't tell how he knew about a secret meeting with the judge. That's not good. A secret meeting with the judge, the DA, and a witness. That's a wild ex-party. There's a lot there. I didn't see the reason. I saw that it had happened, but also Karen Reed today was quite a lot. And my brain is already struggling, and I wanted to cover this because it's look, man, it's not every day that we see a summary judgment granted on the full issue of liability. And that has happened here. And sometimes it is what absolutely needs to happen. And in this case, I think this is the right result and what needed to happen. Saul, good to see you in the chat, friend. You got your UFO Foreo today, or your Foreo UFO today. Have fun with it. Let me know. Let me know what you think. I can't wait. I think you will love it. I love it. The problem is I've been taking my necklace off so I can do like my face masks all down my neck without like getting on my necklace. And it's like been a mess. But Karen Reed was so much today that my brain is mushy at the end of the day. And we've got a long day tomorrow. Members, we've got a long day tomorrow. We've got a podcast recording and a members only. I've got a thing with CBS. And I'm going to try to like find some balance, take care of myself, and start doing laundry and deciding if I need to order anything new for VidCon. Because I think some of the stuff that I took to Nashville for our meet and greet didn't make it back with me, because literally my packing was like hurling stuff out of suitcase. So I think I'm missing a few things. And then my liquid liner ran out today. It's hard. It's just hard. Katie Harrington said, I field produced true crime for 10 to 15 years. One case was tough to get access, but had a psychic interview. The execs didn't use it at all. You're the best. I think there is, and I love all things as woo-woo as we can get them. I really do. I really do. But there are things that are boundaries, and accusing people of murder and accusing people of, impropriety in their profession and what have you crosses a boundary. And there are boundaries to that, even if you think it. Look, there would have been nothing defamatory. That might come across as legal advice. It would be very hard to file a defamation case if what the TikTok psychic had done was call the FBI tip line and send everything they believed to Moscow PD. It would be very difficult to file a defamation case on that. Yes, technically it's communicated to one other person, but it would be very hard to get to the heart of it and say it was made for publicity when it was made to a tip line and made to law enforcement. We would be in a completely different sphere if that were the case, but it's not. It went to TikTok, not to law enforcement. So it's really, really, really tough. Leslie said, fun fact, my senior attorney spent a night in jail for contempt. I spent the night drafting an emergency writ. Leslie, I returned to the courthouse. This is a story I've told on members only, but I returned to the courthouse as a defense attorney was being taken into custody for contempt on a case that a colleague of mine was standing in for. And my colleague was like, what in the fuck? And I was like, I don't know why everything popped off so wildly. I'm so sorry. I was not here. I also had a DA friend of mine that got taken into the back for a timeout. We'll take him back into lockup for a timeout before the judge was considering holding them in contempt. There was much screaming on the part of the DA in the course of trying to get a domestic violence protective order. And I was like, well, I mean, when we talked about it, I was like, but if the protective order got granted and you spent a night in custody, would it be worth it? And he's like, yeah, it would totally be worth it. It was worth it. It was definitely worth it. I'm like, worth it. So anyway, I think there's a lot of room for conversations about law. Today I can't. So let's see. I look forward to hearing about the psychic. I mean, look at the judge just being like, the judge did what I thought they would do. And there are times when the judge is going to rule on the side of one party and they give the other party lots of room. This judge gave an amazing amount of grace, leeway, direction, direct questioning to see if there was anything at all other than it's true because I say so in this case. And there just wasn't. So the judge tried. And I think that's part of what might have been going on with the judge this morning is she's not going to exclude the defense witnesses. And she's like, can we stop with the hyperbole? Like we're not like, I'm going to give you what you want. Can you just speed it up? But Yannetti wanted to make a record this morning and has a right to. Katie, thank you for the gifted memberships. You know what? Let's give some memberships. We got a number of you in here. We've got a members only tomorrow. And you guys have stayed around for like the long haul today. So let's see if this will let me do it. Let's gift a few memberships before we end for the day. You guys are hanging for the day. So thank you. And thank you, Katie, for the gifted memberships. I appreciate it. Make sure you take care of yourself. I'm going to go rest my voice and get some food and try to walk today. Y'all, happy memberships to the chat. I will see you in the members only tomorrow. You will get it. You'll have like a little membership tab and you can go back and watch old videos. If you're new and you need something to laugh at and you are a new member, the Ringo case, just put in Ringo. And it's a Law Nerds After Dark. It is all the innuendos. It is a sex toy case. I mean, it's a trademark case. It's a trademark case. Irish Aiden, congratulations on 24 months. Angela said 2-year anniversary, 2-year EDB anniversary. Thanks, Emily and fellow law nerds for the law education community and laughter. You're welcome. And for all of you that found me during a variety of different cases, we're going to go from trial to trial on this one. And it's going to be wild. This is one time ChatGPT would have written a better filing. The TikTok psychic did argue the nuanced points of, public figure defamation. I don't think the professor's a public figure, but the law in Idaho is also kind of unclear, truly. Just joking said, I can't believe they allow lawsuits like this to even be heard. Well, they do. There is procedure. Sometimes that procedure is slow, but there is procedure, and that procedure has to take place. And that's what sucks for plaintiffs, especially in defamation cases, especially when things can go so viral so fast. What is that professor to do? Their name is forever connected on Google with what this psychic said about them. How do you clear your name? Most people have stopped covering this case. It had a mass amount of media attention, 2 years ago, a year and a half ago, and then no coverage since. So what do you do if you're the professor? You toil, and then eventually there's a ruling, and then what? So sometimes it takes me a minute to swing back to cases, but we don't give up on them. Julissa? I hope I said that. My brain has stopped. I'm sorry. See y'all tomorrow. We're definitely living in Massachusetts. Yes, we are. Rachel said today's trial stream made me renew my membership. Was it my brain explode? Like my head exploded. I'm trying to save money, but I had to hop in to say thanks for all the trial streams. Been a viewer since Step Heard. You're welcome. K-Rab, also good to see you as a member. It's good to see you guys. Thank you for being here. Look, Natalie Lawyer Chick is covering all the stuff going on in the Yug Fuck case. If you're ready for some more fuckery, apparently, and an attorney getting arrested, that. And Runkle will be doing a summary tonight, and I'm sure his defense attorney brain is going to explode over this investigator's text messages. But I think most of the attorneys I've seen online all feel the same way. How are we at trial on this case? So Go check out Natalie. I will see you guys soon. I wish I could redirect. We didn't set it up beforehand, but Natalie Lawyer Chick just put it in and we will go there. Terry C asked, am I going to cover all the Kohberger hearings? Yes, I am. How and when? Not yet, because we're going to cover something that is not murder on the podcast this week. We need a minute and then we'll get back to Kohberger stuff because it's not going anywhere quick. So we will get to it. So for all of you that asked earlier, here you go. We're pickling it out, people. Let's go. We're just going to... We're going to just... Law nerds, have a good rest of your night. I'm sure there is much legal fuckery afoot. Have fun. And I will see you bright and early tomorrow morning back in Massachusetts. No, we're not in Massachusetts tomorrow. Members, I will see you moderately early tomorrow for the behind the scenes recording of the podcast and then the members only live stream. So members, I'll see you guys tomorrow. Everyone else, if you'd like to be a member, you can go ahead and join, and I will see you on those tomorrow. So with the rest of it, you can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.